All right, I think we'll call next the ACN versus Park and Cruise, because there's nothing quite like a good real property case.
Mixing things up. Wow, you're really stepping up.
I'm just flying up.
Yeah, okay. Here's something else.
May it please the court.
Sir.
And opposing counsel, my name is Joe T. Caruso. I represent the defendants, ACN Corporation, and Keith and Notary. In this case, the trial court, in its final judgment, stated that there were no disputed issues of fact, that her decision was based solely on her review and examination of the plat. And based upon that, she cited 4 reasons why the owner of the property, L.L. Kelly, did not intend for the 50-foot road right-of-way shown on the plat to be part of the plat.
Do you agree that is an issue of fact?
That is an issue of law, because the interpretation of a plat or a statute is a question of law.
Well, that assumes it's not ambiguous. I mean, do you agree that this plat is ambiguous?
Certainly, it is subject to different interpretations.
Well, you agree it doesn't contain any words of, the only words of dedication it contains as to a public park. Doesn't have any words of dedication as to the roads.
That is absolutely correct.
And which indicates that they had some idea if they wanted to dedicate something that they knew how to do it. But in any event, I mean, if this is an ambiguous document, and at least to me, I mean, when I looked at this plat for the first time, I couldn't tell you whether the road is in or out of the subdivision. So by definition, that makes it ambiguous if I can't figure it out, doesn't it?
Well, I certainly would not argue with Your Honor.
I'm just kidding. But, I mean, both sides put on their experts, and there was a lot of factual discussion about where the monuments are and you know, the fact that it came from a common grantor. So I guess I'm trying to understand, you know, the standard of review, why it really isn't an issue of fact as opposed to an issue of law. If the plat was clear on its face and it said what it said, like the plats do today, we dedicate to the public, the streets, and et cetera, we wouldn't be having the discussion, but this one doesn't.
Well, the starting point is that the trial court determined for the first reason why the 50-foot right-of-way of Roosevelt was not part of the plat is that it didn't have a dedication. Under the law, at the time this plat was filed, dedications were not required. Dedications that were not required.
Well, there weren't really plats required at the time that this all occurred, but for subdivisions. But the issue that we need to start with is a determination as to whether this is a question of law or a question of fact. And I think that given the nature of the plat, that we have to look at the grantor's intent. And that, I think, by its very nature, is an issue of fact.
Well, certainly the court addressed the grantor's intent, and based upon...
How else do you decide this issue? How else would the trial court have gone about it?
Well, first of all, I think the trial court could you have a plat that, under the law existing at that time, does not require any dedication. That didn't take effect until the platting statute was subsequently passed a couple of months later. And the case law is clear that the platting law that went into effect at a later point in time was not applicable to any plat.
That doesn't help decide the conflict in this case. I mean, that tells us how we got to where we're at today, but it doesn't help us decide the issue, and it doesn't help the trial judge decide the issue. And so I'm trying to understand your argument that this isn't a question of fact, that it's a question of law.
Well, I think the court certainly has got to interpret the plat. And in doing that, if she uses a question of fact and interpreting it and is wrong, then that's a question of law in that she has not correctly interpreted the plat.
Well, do you agree that although the law at the time didn't require words of dedication on the plat,
That is correct.
The law didn't prohibit words of dedication?
I would think that would also be true, Your Honor.
Because this plat contains some words of dedication as to the public park.
Yes.
So, I mean, it seems to me that, I mean, the case really boils down to a simple question, and that is, where is the, I guess it would be the westerly boundary of the subdivision plat? You know, does it end on the east side of Roosevelt Avenue, or does it end on the middle of Roosevelt Avenue, or on the west side of Roosevelt? But, I mean, it seems to me that the judge heard the competing experts. We had 3 surveyors that came in. They all testified to what they said, and they all had their opinions on it. And the judge put some weight on the fact that they found both the original notes of the surveyor and the boundary markers that were at the corner of the platted lots that did not include the street. I mean, those seem to be very fact-driven issues that the judge then, from those facts, was able to reach a legal conclusion, the legal conclusion being, where's the line? But it seems to me that if that's based on competent evidence, that it's hard for us to overturn that. Where am I wrong on that?
Well, I'm not going to suggest you're wrong, but I would
My wife
suggest that
does.
she does not mention
I suggest
anywhere,
that all the time.
anywhere in the final judgment does she mention the name of the only witness the plaintiff had. She does not mention that I am relying upon the testimony of the surveyor. I'm relying on anything she said.
What about the first paragraph of the final judgment, having heard testimony?
Well, but yes, but that didn't mean she's relying on it.
Does the trial court have to identify each particular witness and quote
I think
them?
if she's relying on something, she would certainly want to make note of it. But let me approach this another way. The judge is either right or the judge is wrong. If you look at the plat, if it was the intent of L.L. Kelly,
I'm going to back you up there. Because we're a court of correction of error, and we could disagree with what trial judges do, and I can tell you that that's not uncommon, that we can disagree and can think amongst ourselves that we might have decided a dispute differently, and yet affirm a lower court's decision, because it's not our job to reweigh evidence. And our job is to look to see if it's an issue of fact, whether there's competent substantial evidence to support a trial judge's ruling, even if we might not agree with it. And so to say that the trial judge is right or trial judge is wrong is not necessarily the same approach that we're going to take in looking at this case.
well, I did not request reserving 5 minutes, but I would like to do that at this time, Your Honor. This court said in the case of HJH LLC versus Volusia County, in 2015 that the interpretation of a document is a question of law and is reviewable de novo. So I submit that the trial court's interpretation of this plat, which is a document, is a question of law.
But where was that argument made before the trial court?
It was made, the argument was made before the trial court that that there were private rights which, in addition to the public rights by the implied dedication that existed, and for that reason, the rights of the private rights were superior to anything else that existed.
Are you suggesting that we can look at this plat and know one way or the other whether that street was part of the subdivision or not?
I'm sorry, I didn't hear the last part, Your Honor.
Whether we could look at the plat and make a determination simply by looking at that plat as to whether that road was part of the subdivision or not, just by looking at the plat.
Well, certainly.
Can we tell that? Can you tell that?
Well, I can tell you that in my view of the plat, first of all, you're talking about the intent of L.L. Kelly. If L.L. Kelly...
Exactly right. We're talking about the intent, and that's what I started with, was we're talking about the grantor's intent, which is that's a factual determination.
Well, if it's a factual determination, why did he put the 50-foot right-of-way Roosevelt on the plat if he did not intend it to be part of the plat? Why is it there? There has to be a reason, because if he didn't want it to be part of the plat, he simply could have left it off.
It doesn't tell us that it's part of the subdivision, though.
I'm sorry?
It doesn't tell us that it's part of the subdivision.
Well, it's part of the plat. If it's part of the plat, it's part of the subdivision. If the plat boundary is the west side of Roosevelt, it's part of the plat.
Let me ask you this. We don't have a statutory dedication because there was no statute at the time.
Correct.
So your primary argument below was that we had a common law dedication.
Yes, sir.
But that requires, in addition to finding that there was an intent to dedicate, it requires an acceptance by the public body. In other words, my understanding of the cases out of the Supreme Court talks about the public's acceptance has to be clear, satisfactory, and unequivocal. I mean, the public, no public body ever did anything with this Roosevelt Avenue. They didn't clear it, maintain it, grade it. Nobody ever used it. So how do you argue that there's a common law dedication if there's no evidence of public acceptance?
Well, acceptance is implied. The offer to dedicate it is implied, and then by virtue of the fact there's a case law that if the governmental entity maintains the other roads in the subdivision, that they have impliedly accepted the road that has not been maintained.
What's the case that supports that contention?
I don't have the case.
I mean, the cases that I saw, and I'm talking about a case called Robinson versus Town of Riviera, 1946 Supreme Court. It says for a public dedication, for a common law dedication, you've got to have the owner's intent to dedicate and the public's acceptance to be clear, satisfactory, and unequivocal. The platting of lands and the setting aside of a part for public use constitutes a mere offer to dedicate. Acceptance must follow to complete the dedication. And so I'm not aware of any case that would say the fact that you maintain streets 3 blocks away has any impact on us. But if you are, I mean, I want you to fill me in on that. I'm just trying to understand where the clear and unequivocal acceptance by some public body can be found from this evidence?
Well, I think that if you look at the Defendants Exhibit 8 and 9, there were the certified copies of the County Commission meeting of December 1926 and January 1927, where the Road and Bridge Committee, of which L.L. Kelly was a member, refers to recommending that the county permit the increasing the width of 2nd Street, which was an east and west road, in the subdivision through Roosevelt Boulevard. So if the county is recognizing that an interior road is being, the width is being increased to go through Roosevelt Boulevard, they must recognize that Roosevelt Boulevard is there.
So in your view, that evidence would be clear and unequivocal?
Yes.
All right, let me shift gears, because in your brief you contend, well, even if we don't prevail on the common law dedication, we should prevail on independent private rights. But I didn't see that claim made in your complaint. I didn't see that until, I think it was the motion for rehearing. And I'm trying to understand how the court can adjudicate, how can we say that the court got it wrong if that was never a claim that was made? So my first question is, was that claim made?
The case law says that private rights come into effect when a person...
I really would like you to start by answering the question. I think that was a yes or no answer.
We did not plead private rights, and I submit under the case law that's not necessary to plead it as an affirmative defense.
Did you argue?
It was raised below in the argument of counsel, arguing case law to the court. The private rights cases, which included the primary case of Smith versus Horn, which was a Supreme Court case, that it was argued to the court. There was no objection to that argument being made. It was raised in the motion for rehearing, and the case law says that it's not how it's raised below, but whether it is raised below. And in this case...
I'm sorry, let me make sure I understand your argument. I did see that there was an argument about the Smith case, meaning the Smith case was cited. However, was the argument specifically articulated by counsel as to this private right theory? Because the Smith case also contains many legal principles. And is your argument that an issue is preserved if you cite a case that automatically preserves every argument with respect to every legal issue raised in the case?
I would just cite to the court the case of Maynard versus Florida Board of Education, where they said that the pertinent question as whether an issue was raised below was not how it was raised. In this case, the issue was raised for the first time in a motion for new trial, which was denied by the court, and therefore it was not waived.
You're into your rebuttal time if you'd like to save some time.
I would like to reserve the balance, Your Honor.
May it please the court, opposing counsel. My name is Jason M. Gordon. I represent the appellee in this case, Park and Cruise. I believe the facts as found by the court below was based on competent substantial evidence. If the argument is that it was a review of the court versus abuse of discretion argument, then why would the appellant have two experts testify as to facts? They wouldn't need their experts. It would just be put the plat in, court interpret the plat. But that's not what happened. The appellee had a surveyor, John Campbell, testify, who had historical documents. The historical documents was the actual survey of that property, of the Kelly Park property, which showed
It was the surveyor's notes that really,
Oh, no, there was an actual survey
I
from...
understand, but the surveyor's notes were what caused the one expert to apparently change his opinion on, whether this land was within the subdivision or not.
That's correct. He read the notes, he went through the survey. We're talking about the expert, correct? He came up, he's been doing this for many, many years, he testified. And when you compare the survey compared to the plat, you could see exactly where the monuments line up on the survey as to the plat, except for the fact the survey does not have a road on it, which showed the intent of L.O. Kelly that that road was not part of the plat. In the fact that that survey says showing...
It's part of the plat. We don't know if it's part of the subdivision.
Right, it's not part of the subdivision,
When you
correct.
talk about the survey and the plat, you're talking about that, what they called a working map or something that
Correct.
doesn't show the road. It's a map that shows the lots and blocks.
Correct.
Let me ask you though, let's come back to the law. How do you distinguish the case that counsel relies on, Smith v. Horn?
Oh, Smith v. Horn, the last line of the case says contrary to intent. That's how you distinguish it. The intent is clear. We showed the intent of L.L. Kelly through the working survey. Very simple. That you read the whole case, it's just the last line of the case. If we just show contrary intent, Smith v. Horn doesn't apply at that point. It's the intent of the grantor.
So your argument is that you overcame the, I guess you'd say, a presumption in Smith v. Horn where it says if the owner of the land has it surveyed, mapped, and platted showing subdivisions with intervening streets, the conveyances are made with reference to such map or plat, and the owner evinces an intention to dedicate the easement to the public use. So you accept the position that there was under Smith v. Horn a presumption of dedication, but that you overcame it?
Well, no, I do not. Well, there could have been a dedication, a public dedication pursuant to common law, but there was never an acceptance. So never an acceptance means that there was no dedication accepted. As Mr. Campbell testified, I could offer you $20. If you never take my $20, it was never accepted. And in this case, the roads were never accepted. There was no testimony, even if there is a case that says that if you improve one road, all the roads are accepted. There was no evidence put into the record to show any improvements of any roads, equivalent, substantial evidence. If there's any passing statements, there was no evidence itself. There could have been definite evidence of road work orders. The county could have came and testified. There was nothing to show any improvements of any roads that the court at least...
Is any part of I mean, I don't know if Roosevelt Avenue is confined to this subdivision or not, or if there's a Roosevelt Avenue that extends beyond this. So this isn't a situation where 3 blocks away Roosevelt Avenue is maintained and here it's not.
This is a situation where 3 blocks away Roosevelt Avenue was allegedly vacated by the county, even though they never accepted it. Every part of Roosevelt Avenue, if it was accepted, was vacated by the county at one point. It was never developed.
I don't view the county's action as anything more than just a quitclaim deed. We don't know if we have any interest, but if we have, we give it up.
I agree with you, and that was my point. It's like a quitclaim deed.
But what I'm trying to understand is there a Roosevelt Avenue any place that's maintained?
No.
I mean, counsel says that there's a case that says if you maintain the streets nearby, you impliedly accept the undeveloped streets. And I'm not familiar with that, but I accept him at his word. Okay.
But I put forth that if that's true, there was no record, no testimony, substantial, equivocal, that would show the acceptance by the improvement of those roads. There was no testimony to show the actual improvements, if they were done, not done, or if there were roads there, when were they improved? Prior to the dedication, prior to the plat being filed, after the plat filed? Nothing was put on. There was no testimony whatsoever about that issue as to any improvements that would show that it was an acceptance. the record's void of that. The trial court made various findings. I don't want to cloud the issues, but just to point out to the court, there was a bunch of deeds that were put into evidence in this case, and one being from 1927 from L.L. Kelly to the county. And it's kind of funny because in that deed, the consideration states as follows: for in and consideration of $100, and for all abandoned rights or ways reverts back to L.L. Kelly on lands owned by him. So it looked like back in 1927, L.L. Kelly entered into a contract with the county pursuant to this deed, which is Exhibit R-709 on the record, saying that whatever reverts back will go back to him if the county doesn't accept it. And that deed's been sitting there since 1927. So not to cloud the issues, but want to let the court know that there's a contractual issue that was out there that was put into evidence as a deed. This started off as a simple case. We had Park and Cruise just wanting to know where their boundary line was. Was it east or west of Roosevelt Avenue? Based upon the testimony that was presented, I believe the court had more than substantial evidence to lay that boundary line down and find that the road was not part of the subdivision, and the intent that the road was never going to be part of the subdivision, especially looking at the other side of the road where the court notes there's open end onto Park and Cruise's property. So as such, that Park and Cruise, the intent was that that would all be part of that property, the parent property that was cut off, since L.L. Kelly owned both properties. I don't believe there was anything to show opposite or any testimony that refutes any of the findings of the court. And as I put forth, that the findings driven, this is a fact-driven case. This is a very unusual case. You can't just look at a plat as appellant says and decide how this thing would go. If there's any other questions.
I have a question regarding what's your response to the appellant's argument that with respect to private rights, even if there was no acceptance and therefore no dedication, nevertheless, just by indicating this private road.
Oh, the private right argument?
Yes.
That's defeated. It's perfect. It's defeated in the final judgment because he has ingress egress. For him to have that private right argument, he would have to show he couldn't get to his property, and he relied on that road. That private right argument can be refuted, and that's what the court did. Even though the court didn't directly address it, they did find that he had the ingress egress, and I believe there's a case on that. Let me see if I can find that. I believe it was. I'm sorry, if a minute.
I think it's Powers versus Scobie,
Excuse me?
the complete enjoyment rule, where I think that's the case that says that if you've got other access, then you don't get those private rights.
Right. I offhand, I know I have it. It's in fact, I almost here. I think I found it. I believe that came out of the Miami City versus. I'm sorry, City of Miami versus Florida East Coast Railway. And they talked about the platting of the land and sale of lots pursuant thereto creates between the grantor and the purchaser a private right to have space marked upon lots as streets, alley, parks, etc. remain open for egress and egress, and does not confer any public rights until it's been accepted. So they only have the private right. Doesn't go to ownership. It only goes to ingress and egress, and the court found that they have that. So that was defeated by the court unknowingly. If there's any other questions?
Thanks, sir.
Thank you.
All right, you've just got just short of 2 minutes for rebuttal.
Yeah. I know I have limited time, but I just want respond to opposing counsel saying that when he was asked about Smith v. Horn and how do you get around the private rights that's set forth there, and he said because it refers to contrary intent. But every one of the cases say the contrary intent has got to appear on the face of the plat or in the chain of title and the record conveyances of the property. And there was no contrary intent on the plat, and there was no contrary intent in any of the chain of titles or reservations in any of the deeds to any of the lot owners. The last issue, which I think the court clearly was an error, is she found that the plaintiff in this case had L.L. Kelly's reversionary rights. The reversionary right issue, as it relates to a common law dedication, was put to rest by the recent case of Lehman versus Coconut Bayou Association, which is cited, is only reported about 3 months ago, 269 Southern 3rd, 591.
Did the appellee discuss reversionary rights during his argument? Am I missing something here?
I'm sorry, Your Honor?
Did he discuss reversionary rights in his argument?
Yet that's one of the points that the court found, that he had L.L. Kelly's reversionary rights.
In the appellee's argument, did he discuss reversionary rights in his oral argument here today?
I don't think he did, Your Honor.
Because this is rebuttal, and the idea of rebuttal is that you address arguments raised during the argument.
Well, I didn't get an opportunity to get to reversionary rights in my first approach.
You can rely
but
upon your brief. All right, thank you, sir. All right, we'll take a